The U.S. Department of Ed reiterates in Section G the IDEA requirements that if the ARC determines that the student's conduct was a manifestation of a disability, the ARC must conduct an FBA and develop and implement a behavior intervention plan. If the district had already conducted an FBA and developed a behavior intervention plan before the behavior occurred, the ARC must review the behavior intervention plan for the student and modify it as necessary to address that behavior. If the ARC determines the student's conduct is not a manifestation of disability, or if the student's placement is a change to an IES based on special circumstances, the district must provide the student, as appropriate, an FBA in behavior intervention services and modifications that are designed to address the behavior so that it does not recur. IDEA requires states to establish and maintain qualifications to ensure that personnel necessary to carry out the purposes of IDEA are appropriately and adequately prepared and trained, including that those personnel have the content knowledge and skills to serve children with disabilities. Districts must ensure that assessments and other evaluation materials used to assess a child are, among other requirements, administered by trained and knowledgeable personnel. In order to meet IDEA requirements and to be proactive in preparing for situations that may occur regarding behaviors, districts should review with school personnel who the properly trained professionals are in the district that may conduct FBAs and how those are conducted. School personnel should also be aware of the district and school-wide positive behavioral interventions and supports that are available for students with disabilities. Section H. This section of the document covers provision of services during periods of removals and reiterates a district's obligation under IDEA to provide services once a child's cumulative days of removal in a school year exceed 10 school days, i.e. beginning with the 11th cumulative day and during any subsequent days of removal. They also clarify who is responsible for determining the services to be provided. The ARC is responsible when the removal constitutes a change of placement, and school personnel in consultation with at least one of the child's teachers when the removal is not a change of placement. Once students' cumulative days of removal in a school year exceed 10 school days, beginning with the 11th cumulative day and during any subsequent days of removal, the district must provide services in accordance with the regulations as described on this slide. So some ways to apply those key takeaways from this section. Review systems in place to document and analyze attendance, behavior, and removal data. Also review district and school plans for providing services in an IES setting for students with disabilities. Section I. This section provides updates and clarifications regarding protections for children not yet determined eligible for services under IDEA. The guidance clarifies when a district would be deemed to have knowledge a student not yet determined eligible is a student with a disability, including if the student is participating in a multi-tiered system of support, such as response to intervention. They also provide guidance on how to conduct an MDR prior to determination of eligibility when the district may have little to no information about the student's disability, and the purpose of the review is to determine whether the behavior is the result of the student's disability. They also address the steps the state education agency and the district can take to ensure that the parents are informed that concerns about the student's needs for special education and related services must be expressed in writing for the disciplining protections to apply. A district would be deemed to have knowledge that the child is a child with a disability if, before the behavior that brought about the disciplinary action occurred, 1, the parent expressed concern in writing to supervisory or administrative personnel of the appropriate educational agency or to the child's teacher that the child is in need of special education and related services. 2, The parent requested an evaluation of the child's eligibility for special ed and related services under IDEA. Or 3, the child's teacher or other district personnel expressed specific concerns about a pattern of behavior demonstrated by the child directly to the district's director of special education or to other supervisory personnel of the district. So what steps can a state education agency and district take to ensure that parents are informed that concerns about their child's need for special ed and related services must be expressed in writing in order for the discipline protections to apply? The guidance reiterates that districts and state education agencies may include in its child fund policies and procedures ways to provide information to the public regarding IDEA's requirements and protections for disciplinary purposes when a parent has expressed in writing to school personnel concerns regarding the child's need for special ed and related services. Some examples of ways to provide such information include making the information available on the state website, the district's website, in parent handbooks, or in the state or district procedural safeguards notice. Districts and schools need to make sure school personnel are aware of the instances in which a district would be deemed to have knowledge that a student is a student with a disability. For instance, participation in a response intervention process in and of itself would not meet the standard. However, if participation in the response intervention process is based on the parent or school personnel expressing concern in writing that the student is in need of special ed and related services, and the parent has not prevented evaluation from occurring, then the district would likely be deemed to have knowledge at the time the parent or school personnel expressed their concerns in writings. Districts should review evaluation procedures since once a district is deemed to have knowledge that a student is a student with a disability, the MDR may not be postponed until the initial evaluation is completed or until the ARC is held. The ARC must conduct the MDR, and IDEA does not include an exception that would give the district additional time to complete an evaluation of the student's eligibility.